Hi everyone, and welcome to the video lecture Probation and Parole Professionals. In this lecture, we'll discuss the qualifications and job duties of community supervision officers. The specific requirements of probation and parole officers differ widely by state and local jurisdiction, but there are a few qualifications that are pretty common requirements for most community corrections officers. The first is educational requirements. In the past several decades, the focus on community correction efficacy and probation and parole officer professionalism have led to increases in educational requirements for probation and parole positions. Although the standard used to be a high school diploma or a GED, many of today's agencies require some college experience for qualified applicants. Another common requirement for probation and parole positions deals with the criminal history of the applicant. While having the criminal history will not automatically disqualify potential applications, it is understandable that certain criminal histories may indicate that an applicant is unsuitable for the job, given the role that the probation and parole officers play in an offender's life, as well as the high level of autonomy and discretion provided by their employment. Most agencies have rules that restrict employment for those applicants who are currently under supervision, or applicants convicted of certain crime types such as sexual assault or domestic violence. The next qualification is one that's often overlooked when discussing probation and parole officers. A well-qualified probation and parole officer is one who can communicate clearly through both oral communication and written communication. Remember that probation and parole officers are not only engaging in contact with the offender, but they're also communicating with the judge, the offender's family, the victim and the victim's family, treatment providers, community partners, counselors, and other professionals during the normal course of their duties. These contacts must be recorded in written documents for the court in case there are questions about the offender's behavior or supervision progress in the future. Last, probation and parole officers must have extensive knowledge of the criminal justice system and the legal requirements in their jurisdiction. Officers writing pre-sentence investigation reports must know what information is necessary to collect and must be able to determine appropriate sentences for recommendations. Field officers must understand the laws impacting their day-to-day activities, including laws relating to search and seizure, offender privacy laws, and officer liability. To give you some specifics about parole and probation officer qualifications, I have two examples here from real job postings. The first is for a district parole position in Texas. In Texas, parole officers must have at least a bachelor's degree, and degrees in criminal justice, counseling, or some kind of social work or sociology related field are preferred. There are also requirements relating to the criminal history that I discussed, such as no pending charges and no felonies within 15 years. As stated, some conviction types will make applicants ineligible for a probation and parole position. Applicants with convictions for domestic violence, for example, regardless of time passed since conviction, are completely ineligible to apply. As discussed, previous criminal justice experience or education is preferred. Now, internships are a great way to get experience within the criminal justice field as a way to provide you with some real-world experience that can go a long way on your resumes. Now, Texas parole salaries depend on the pay grade that the officer is currently at, as well as the number of months that they've been employed by the state. Currently, parole officer salaries in Texas range from $39,000 a year for an entry-level parole officer to $63,000 a year for a parole officer supervisory position. In Texas, if you apply for a parole position, you're actually put into a pool of applicants for positions across the state. On the state application form, there is a section of the application where applicants select their top 3 location preferences. However, positions are filled on an as-needed basis, so you may be offered a position at another location. That's just something you need to be aware of if you intend to apply for a supervisory position here in Texas. Here's another example, and these are the requirements for a federal probation officer. Now, many of the requirements are similar to Texas parole, but you can see some differences. For example, depending on the geographic location, fluency in another language may be preferred for applicants. For those of you who are thinking about a minor, a foreign language minor can be really useful as a resume builder when applying for criminal justice positions. Once hired, federal probation officers are required to attend a training academy in Charleston, Virginia, during which candidates are tested through physical, written, and firearms testing. Now, I have a quote here from a current federal probation officer listing. It reads, quote, "The successful applicant must be mature, responsible, poised, organized, and meticulous. Must possess a positive attitude, integrity, tact, good judgment, initiative, and the ability to work with a wide variety of people with diverse backgrounds. Must be able to meet all court deadlines and dates. Proficiency with Word or similar software, and excellent oral and written communication skills preferred." You can find the full position advertisement in the module supplementary materials. You can also always look for open positions for federal probation officers at usajobs.com. This website provides you with all of the open positions within the federal system. So this is a great place to look if you're interested in federal employment. Now, you may have noticed the requirement for a written exam from the federal probation position I showed you. This type of requirement tells you about the selection process of the federal probation officers. There are 3 types of hiring systems for criminal justice personnel. The first is the appointment system, in which probation and parole officers are interviewed by agency management. Candidates are selected based on how well they interview and how well the interviewers believe that they're going to fit into the agency itself and with other agency personnel. The advantage of this form of hiring system is that the interview process allows the agency the best flexibility to find someone who works well within that specific environment. Unfortunately, this form of hiring system can also be influenced by political pressure to appoint certain individuals. The opposite form of hiring system is called the merit system. In the merit system, anyone who meets the minimum qualifications can apply, but all applicants are required to participate in a competitive written exam. Candidates are ranked based on their exam scores, and the final selection is based solely on the best exam score. Unlike the appointment system, the selection process is based solely on the applicant's qualifications, and it can't be influenced by political association. However, a pure merit system selection relies entirely on a written exam, which doesn't allow for the assessment of the candidate's interpersonal communication like an interview using the appointment system does. For that reason, a lot of agencies will use the combination system, in which a written exam is issued to determine a pool of qualified candidates who are then interviewed by an agency in order to select a finalist. By using both the written exam and the interview, this system of hiring limits the political manipulation to ensure that all final candidates are qualified and possess the necessary skills, but it also allows the agency leniency in assessing a candidate's interpersonal skills and determining best fit with the other personnel. The last thing I want to talk about in this lecture is the concept of immunity in parole and probation positions. I talked previously about the need for probation and parole officers to understand the legal requirements and restrictions affecting their day-to-day activities. This is particularly important because probation and parole officers are not guaranteed immunity when it comes to criminal charges and civil lawsuits. Probation and parole officers have what is called qualified immunity, meaning that in most cases, the officer is immune from criminal and civil charges as long as they were acting in good faith of their duties. However, there are 2 types of cases in which officers can be held liable for an offender's actions. The first is negligence. An officer can be liable for an offender's actions if the officer failed to act in a way that he was supposed to, and if that failure to act was determined to be a proximate cause of the injury or the damage caused by the offender. For example, if an officer was required to make sure that a supervised offender was attending mental health treatment, but the officer didn't check up on the offender's progress, and then the offender ended up harming someone as a result of his mental health, that officer could be held civilly liable for this harm. The other way in which probation and parole officers may be found liable is called failure to warn. The courts have ruled that due to the special relationship between supervision officers and offenders, officers may be able to predict some types of risk and warn people of imminent danger. Now, one caveat here is that the risk has to be reasonable, foreseeable risk. For example, if an offender on parole for domestic violence told his parole officer that he wants to beat up his victim, the officer may be required to warn the victim or law enforcement about the offender's threat because this would most likely be considered a foreseeable risk. He's done it before, chances are he may follow through with this again. However, if the same offender said he just wanted to, quote, beat somebody up, the offender's future behavior would not be easily foreseen. So it's likely that the parole officer wouldn't be held liable for any future assaults that this offender completes. One high-profile case of supervision officer liability was the J.C. Dugard case. J.C. Dugard was 11 years old when she was abducted as she was walking home from the bus stop. Dugard would not be located until she was 29 years old, when her kidnapper brought her along to a meeting at his parole officer in California. Investigators found out that Dugard was being held for 18 years by Philip Garrido and his wife, Nancy Garrido, on their property. During the entire time of her disappearance, Garrido was under parole supervision for a previous kidnapping and rape conviction from 1977. When Dugard was first kidnapped, Garrido was on federal supervision, but in 1999, his case was transferred to state supervision. He continued under state supervision until the day that J.C. Dugard was discovered, at which time it was discovered that he had actually fathered 2 children by Dugard while she was held captive. When Dugard was discovered, the Dugard family brought a civil lawsuit against the state of California for the negligence of the parole officer supervising Garrido. They claimed that the parole officers supervising Garrido did not act in the way that they were supposed to, and that the result of their actions was the continued sexual and physical abuse of J.C. Dugard. California's government approved the settlement in 2010 in this lawsuit. One of the reasons that the Dugard case resulted in a settlement was due to the serious problems noted during the later investigation of Garrido's supervision activity. Officials documented the lax supervision that Garrido was subjected to in a report that was later released by a chief federal judge of Northern California. Officers noted in this report that there were significant gaps in Garrido's supervision records that suggested nothing was done to supervise the offender during long periods of time. When contacts were noted, they were usually done in the office or by phone with the treatment provider, and officers rarely visited Garrido's residence, where, of course, we now know he was holding J.C. Dugard. Overall, even though Garrido was considered a high-risk offender, the probation officers only visited his residence 10 times across 10 full years of supervision. In fact, in 3 separate years, probation officers never visited Garrido's residence at all. Another concern raised in the report was the lack of failure to warn and failure to check into concerning patterns of behavior. A report of Garrido stalking his previous victim was ignored, with the officer writing that the victim was seeing things as a result of hysteria. There were also other situations in which Garrido's interactions with women should have given his supervisor officers cause for concern, especially given his previous charge of sexual assault. The report found that there were several documented reports of women at Garrido's work feeling nervous around him, but these were never followed up by the officers. Additionally, officers even approved Garrido working temporarily as a door-to-door salesman, even though this was a very risky endeavor given his previous history. Overall, the report documented that Garrido's parole supervision was extremely problematic. It noted that several of Garrido's actions considered a parole violation were either glossed over or even outright denied in the supervisory log, even though the agency had a zero-tolerance policy towards violations at the time. This quote comes from the report itself, and it shows how the report left out vital information that may have alerted authorities that Garrido was showing a pattern of concerning behavior and required more supervision contact. Given all of these factors, it was believed that more effective supervision would have resulted in the earlier discovery of J.C. Dugard, so the city was held liable for their failure to manage the offender. One of the factors that influences the ability of an officer to carry out their duties is their caseload. Caseload is the number of offenders that are assigned to each officer. Remember that we've discussed caseload and workload previously. Workload includes a calculation for offender risk, and it's usually measured in terms of contact hours. Caseload, on the other hand, does not take into account risk or any type of special conditions. It's simply a numerical value indicating total number of parolees or probationers assigned to a single officer at one time. There are several ways that offenders can be assigned to a supervisory officer. Traditionally, offenders are randomly distributed between officers. This is known as the conventional model. There are slight variations to the conventional model that can help reduce offender-officer workload, either by ensuring an even distribution between officers or by taking geographic location and commute time into account when determining officer caseload. These variations can be particularly useful for large jurisdictions that involve both rural and urban areas. Due to the large spread of people, Officers in rural areas may require a commute of several hours between offender contacts, whereas officers in urban areas their offenders are often more clustered together, so a city-based officer can visit multiple offenders within the same time frame that an urban officer can only contact one. There are some agencies that prefer what's called the specialized caseload assignment process. Specialized caseloads mean that each officer is assigned to a particular category of offenders to supervise. So a supervision officer may have a caseload of entirely sex offenders or all drug offenders, etc. Specialized caseloads do have advantages with regards to officer training. Ideally, officers should be knowledgeable about community resources, job opportunities, counseling programs, and the legal restrictions for each type of offender that they supervise. It would be easier for an officer to remain up to date on all these factors if they specialized with one type of offender group. For example, someone who works exclusively with sex offenders would probably be more knowledgeable about sex offender restrictions and legal changes than someone who simply supervises one or two sex offenders at a time. Now, sometimes these systems are not exclusive either. For example, the Federal Probation Office in Nebraska used a conventional model of case assignment for most cases, but there were some exceptions for which specialized caseload was used. One of these was the Indian reservations within the state, which were usually very remote and they were several hours away from the main office. In addition to the commute time, Indian reservation supervision is governed by different rules than non-reservation supervision, and the community was very distrustful of outsiders. So it took time for probation officers to build relationships with the residents within the community. For all of these reasons, the federal probation officers in Nebraska had 2 officers who were assigned to all of the reservation cases. These officers received specialized training relating to Indian reservation concerns, including participating in a conference specific to tribal community supervision. The reservation officers also had a reduced caseload because of the increased commute time needed for their fieldwork. The Federal Probation Office also had a specialized mental health officer who handled all of the severe mental health cases. Like the reservation officers, the mental health probation officer received specialized training in mental health concerns, and so she was very knowledgeable about treatment and supervision of mental health offenders, and then she received a reduced caseload as a result of the many high risk of the mentally ill among her supervisees. Regardless of who they supervise, all probation and parole officers have a duty to supervise the offender and to maintain public safety. One of the problems with the duties of a supervision officer comes from the different and often conflicting roles that supervision officers play. Remember, we spoke previously about 2 different hats for community supervision officer. They must be a controller, enforcing the rules, but they also must be a caseworker, providing rehabilitation assistance to the offender. The specific roles that each officer must play include roles within both categories. The controller roles include being both a detector and an enforcer. Supervision officers must identify those offenders who pose a risk to the community. They must enforce the court-ordered requirements of the offender's supervision, and they must protect the public by regulating the offender's behavior. All of these roles are focused on the controller aspect of the supervision officer job. At the same time, supervision officers must also work as a broker or as an educator or mediator for the offender. They must be knowledgeable about community resources, and they must be able to provide assistance to the offender as they work to reintegrate into the community and to rehabilitate themselves. Both of these roles are offender-focused, with the goal that community safety will result from the completed offender rehabilitation. One of the constant struggles of probation and parole officers have is the balancing of these 2 roles. As we discussed previously, offenders will not rehabilitate themselves overnight, and it's expected that offenders will make some mistakes on supervision even as they maintain overall progress towards rehabilitation. It is the challenge of community supervision officers to maintain community safety by punishing these rule violations while also maintaining a positive environment for offender change. The term role conflict is used to indicate the stress that this puts onto an officer who is trying now to fulfill multiple conflicting roles at one time. One of the challenges in assessing role conflict is that not all supervision officers try to achieve all 4 roles. In supervision literature, this difference is called the officer orientation, or the officer's perception of a community supervision officer's role. This orientation has been the result of multiple research studies, as researchers have identified officer orientation as being influential in reducing recidivism and maintaining public safety. One of the original typologies of officer orientation comes from a 1972 publication by Klockbar. In it, he defined 4 different orientation styles. The first, law enforcers, are those officers who stress the law enforcement aspect of their role. These officers focus almost exclusively on maintaining public safety by adhering very strictly to the rules and requirements of the offender's supervision. Law enforcement officers are very firm and they're very focused on rule enforcement. Time servers are law enforcers who enforce the rules less out of concern for public safety and more as a way to meet the minimum requirements for their position. These individuals lack enthusiasm for either aspect of their job. Klosker notes that the time servers, quote, don't make the rules, they just work there. Therapeutic agents, on the other hand, emphasize the treatment portion of probation supervision, and they focus on offender change and development. Therapeutic agents focus on providing empathy and help for the offender, and Klosker notes that this type of officer would be likely to belong to professional organizations and have education or training backgrounds relating to social casework. The final type of officer that Klosker identified is the synthetic officer, who utilizes both treatment and law enforcement components as part of their duties. This type of officer balances the controlling, rule-affirming attitude of law enforcers with the emphasis on offender change and development of therapeutic agents. This role in particular is one that more recent publications support for both existence and effectiveness. Researchers note that today's probation parole duties, as outlined by the legislature, often include components of both law enforcers and therapeutic agents. So the synthetic officer is more of a standard requirement rather than being a specialized type of officer orientation. Researchers have also identified this balance as being the most effective for offender supervision, combining caring and authoritative personas that inspire trust and confidence by the supervised offender. This balanced officer lowers the risk of recidivism, thereby achieving the public safety goals while still maintaining a focus on offender rehabilitation. All right, well, this concludes the Probation and Parole Professionals video lecture. Thanks for watching.